Yes. Did you review the true bill of indictment? You're saying yes? Basis?
Yes.
Did you understand you're charged with intentionally or knowingly committing bodily injury against a child, elderly, or disabled person at a state facility?
Yes.
That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine.
All right, everyone, here we go. And let me tell you, this case is intense. What you're watching is a caregiver standing before the court, facing a second-degree felony for injuring someone who is elderly, disabled, or otherwise vulnerable. That's a charge that carries a 2 to 20-year prison sentence and a massive fine. But here's the twist. Instead of locking her up, the state is recommending deferred adjudication, which is basically probation, meaning if she plays by the rules, she avoids prison time and even a conviction on her record. Sounds like mercy, right? But don't think this is going to be smooth sailing. The judge isn't holding back here. He's about to grill her on qualifications, responsibilities, and the bigger failures of a system that lets undertrained workers take care of patients with dementia and Alzheimer's. By the end, you'll see not just a personal downfall, but a scathing critique of an entire industry. Stick around, because this isn't just legal drama. This is a story that hits home for anyone who's ever trusted a loved one to a caregiver.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not, punishment is to be assessed at $1,500 fine. State recommends deferred adjudication. There's to be no contact with the complainant, the anger management course, and you're prohibited from practicing as a nurse in the state of Texas. Did you understand that to be the plea?
Yes.
Defense, is that the plea?
Yes, it is.
State, is that the plea?
It is, Judge.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State, any evidence?
State tender states wanted attachments, Judge.
No objections.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Understands, she should not have slapped this individual. She does accept responsibility for it. She would just like to move on and be able to work and complete her probation without any problems.
Did you catch that? The defense is already framing this as a minor misstep, something she can just move on from. But let's be real. This wasn't just a workplace dispute. This was slapping a vulnerable patient. The judge immediately pivots, asking, was she even qualified to be there in the first place? And here's the bombshell. She's not a licensed nurse, not a CNA, just someone with a high school diploma hired as a caregiver. This isn't just about her mistake. It's about hiring practices. Facilities often cut corners, bringing in underqualified workers at low pay. So here's my question for you. Is the bigger blame on her or on the company that allowed her near fragile patients in the first place? Drop your thoughts in the comments. I want to know where you stand.
All right, so how much training does she have in the field? Is she a licensed nurse, or is she a person that somebody hires and says, hey, we need somebody to come in as a caregiver?
She will have to answer that one.
All right, are you a licensed nurse?
No, I'm working towards getting my CNA.
All right, so this is a situation where somebody just hired you to come in and work in the facility.
I'm a caregiver.
All right, so what's your level of education to be a caregiver?
I finished high school.
All right. See, this is what I mean. Everybody's just letting everybody be a caregiver. And the problem is that being a caregiver for somebody, I think that's sort of like a calling. You have to have said, you know what, I'm going into that field because you're dealing with people who have dementia, Alzheimer's, people who can't take care of themselves, people who need somebody to bathe them. The patient gets upset because they're not doing what they're allowed to do anymore. They can't communicate because they have dementia and Alzheimer's. Then everybody and their mothers just hiring random people, paying them minimum wage or less than. And then we end up here with somebody slapping somebody who has dementias and Alzheimer's.
And there's the judge laying it bare. This isn't just about one act of violence. It's about the systemic negligence that puts untrained people in charge of our most vulnerable citizens. Think about it. Dementia and Alzheimer's patients can't always communicate. They can't always report abuse. So when the judge says, we end up here, he's pointing to a much larger failure. Minimum wage jobs, zero professional training, but life and death responsibilities. This case is no longer just about her. It's about how society values elder care. Let me throw this out to you. If you discovered a facility was staffed this way, would you ever trust them with your family? Yes or no?
So I know y'all say she's prohibited from practicing as a nurse in the state of Texas. Okay, but she's not a nurse. She's not licensed to be a nurse. This is just somebody that somebody just hired off the street and said, hey, you have a high school diploma. You want to receive minimum wage to take care of people that nobody else maybe wants to take care of. And this is where we end up. And what was the name of this facility? Let me see. Chapters Living of San Antonio. All right. This is what the court is going to do. Does anybody want to speak to length of probation? The state is asking for 3 years. All right. Court is going to sentence you to 5 years deferred adjudication. There's a $1,500 fine.
All right, let's break down the sentencing terms, because this is where it gets serious. The state wanted 3 years of probation, but the judge doubled down, ordering 5 years deferred adjudication. That comes with strict conditions. No jobs in healthcare, no working with minors or the disabled, no practicing as a nurse, 120 hours of community service, and mandatory anger management. Translation? This isn't just probation. This is a hard reset on her entire career path. And the judge is crystal clear. She should never again work around patients with dementia, Alzheimer's, or mental health issues. This is the justice system drawing a line in the sand, saying, you don't belong in this field.
There is to be proof of employment within 30 days. There's to be no employment as a home health care provider, no employment with working with minors, no employment with working with people who are disabled. There's to be no practicing as a nurse in Texas or anywhere else. So I'm just going to say no practicing as a nurse. There's to be regular reporting by Zoom or in person. There's to be regular random UAs. 120 hours of community service restitution. The $1,500 fine will be probated. There's to be anger management. I'm ordering anger management because you all agreed to it, but it just appears that you were a person who should never have been working with someone in any type of facility or young children or people who have mental health issues. That's just not a field for you. Probation, is there anything else? Yes. What county are you in? I'm sorry, where?
Cook.
All right. She's allowed to transfer to Cook County in Illinois. Is it Illinois?
Yeah.
And Judge, if I may,
Yes.
is this court inclined to include a no contact for Ms. Maria La Rochelle?
Yes. And there's to be no contact with Maria La Rochelle. And there's to be no residing with the elderly. And for the court, I'm putting elderly at anyone over the age of 60. Probation, anything else? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, to you, don't take any more of these positions that requires you to have patience and that requires you to be with someone who has dementia, Alzheimer's, they're elderly, they need somebody to be kind and patient with them. You shouldn't work in those positions. Do you understand?
So here's where we land. The defendant avoids prison, but walks away with 5 years probation, a $1,500 fine, community service, anger management, and a lifetime ban from working as a nurse or caregiver. The judge didn't just sentence her. He condemned the entire facility that hired her, pointing out how dangerously low the standards have become in elder care. And honestly, that's the bigger lesson here. Yes, she made a terrible choice, but the system itself practically set the stage for it. What do you think? Should facilities face harsher penalties for hiring unqualified workers? Or is this solely on the caregiver? Let's talk about it in the comments.
Yes.
And I do fault the company that hired you as well. All right. I'm going to send you to the breakout room. Probation will go in the breakout room with you and go over conditions. And I will place you in breakout room number 2. Mr. Bellevue, do you have anyone else with us?
I do not.